Hello, everyone, and thank you so much for joining us. Welcome back to the Creative West Capacity Building webinar series. My name is Ashanti McGee, and I'm the Grants, Awards, and Programs Manager here at Creative West. Today's webinar, we're focusing on contracts, pricing, and artist self-protection. A recording of this of this re- sorry, a recording and the slide deck will be sent to all participants following the meeting. While you're here today, please take a moment to complete our feedback survey. Your responses help us improve the series and focus on the topics that matter most to you. We are also joined by interpreters from ASL interpreters from Indigenous Ways. We appreciate your interpretation for these sessions. Next, I want to introduce my co-facilitator, our Grants, Awards, and Programs Coordinator, Marcelina Ramirez. I'll pass it over to Marcelina to start us off.
Thanks, Ashanti. I'm going to be going over just a few housekeeping things today. For example, our Zoom norms. Please keep your microphone muted when not speaking. It's in the far left corner. You may rename yourself to your first and last name and your state or organization name if applicable. You can click on the participants, hover over your name, and click the More button to change. We have ASL interpreters here with us today and live transcripts. Closed captions are also turned on. You can view or hide them, change the size as well as other functions by using the up arrow on live transcript, which is either in the middle of your screen or behind the More button with the three dots on the right side of your screen. There will be a Q&A at the end. To ask questions or comments, please use the raise hand function. You may also write your question in the chat anytime, and it will be answered during the Q&A. Click on Reactions in the middle of your screen and choose Raise Hand, or click on Chat in the middle of your screen to write your question or comment. As a reminder, the Q&A will be at the end. For our preamble, Creative West shares a fundamental and abiding commitment to equity, accessibility, inclusion, and belonging. We recognize and greatly appreciate the extraordinary contributions of our team and the impact we seek to have in our communities in the West and beyond. We understand that trust is built slowly with communities we wish to serve that experience generational betrayal and trauma. Our shared commitments provide a grounding for generating spaces of trust and safety within our team and in the communities we seek to serve through our work. We are dedicated to seeing these commitments reflected in our work over time consistently. Today's shared commitments. We value humility, learning from our mistakes, and asking questions to gain deeper understanding. We feel empowered to hold one another accountable, establish boundaries, and ask each other for help. We lean into discomfort by facing challenges and conflict with openness and grace. We stay present by listening actively, being mindful of body language, and participating to the fullest of our ability. We share from our own experiences and grow as a team through the inclusion of every individual voice. We prioritize accessibility and are mindful of our language and ensuring belonging for all. Alrighty, back to you, Anika and Ashanti.
Thank you so much, Marcelina. Now I would like to introduce our Director of Grants, Awards, and Programs, Anika Tené, who will facilitate this session.
Thanks, Ashanti. Hello, everyone. Can you hear me okay? Can I get a thumbs up if you can? All right, thank you so much. So again, I'm Anika Tené. I'm the Director of Grants, Awards, and Programs at Creative West. So glad that you all are here today, and please feel free to share in the chat where you're zooming in from and your name. We'd love to know who you are. But our session today is about artist agency, the agency that artists have or should have, and about equipping artists with the tools they need to advocate for themselves, to understand their rights, and approach contracts not as something that's intimidating, but as something that protects relationships and their creative work. We know many artists are balancing multiple roles. You're a creator, you're an administrator, you're a negotiator. And it goes without saying, you're a sister, you're a mom, you're a brother, you're a father, you're an uncle, so many hats that we juggle. but in the professional space, often without formal training in business. And today is really about building confidence and clarity in that space. So let me give you a quick roadmap for our time together. Each of our guests offer about 20 minutes of framing, sharing practical insights and tools and all the things that they've put together for you. Then we'll shift into more of a talk show style conversation where I'll moderate and invite them to build on each other's perspectives. We'll wrap with Q&A, and we'll also keep an eye on the chat in case something feels especially timely to address in the moment. And attendees, please feel free to start using the chat now. If you came with burning chat questions or comments or ideas or thoughts, please put them in now. Let's get the chat going really robustly. And then as we go along, if you have comments or questions, an aha moment, any resources you might want to share for the good of the group, please feel free to do so. The chat is yours. So now I'm honored to be joined by two incredible guests. Spencer Cross is an arts and entertainment attorney who works directly with creative professionals on contracts, intellectual property, and business structure. Before becoming an attorney, he worked for over 20 years as a designer. So he deeply understands the lived realities of creative labor, scope creep, and navigating client agreements. Meredith Badler directs or is the deputy director of directs Colorado's Volunteer Lawyers for the Arts program. And she's also a deputy director at the CBCA. She'll share more about that. But she helped to launch Colorado's VLA more than a decade ago. She works closely with artists navigating legal challenges and is deeply connected to the National Volunteer Lawyers for the Arts. You'll hear us say the VLA network, helping artists access legal resources across the country. So together they bring both practical legal insight and real world artist advocacy to the conversation. So we're going to start with Spencer, and I will turn it over to you to kick off your presentation. You're on mute, Spencer.
All right. Hello, everybody. It's nice to be here. So as an initial matter, I'm sure you've all heard these things before, but I do need to point out or remind everybody I am a lawyer, but I am not your lawyer. Everything I say today is intended to be for educational. I'll be sharing my opinions about hypothetical situations and best practices, but you shouldn't assume that any of that applies directly to your specific circumstances. So always consult an attorney about your specific situation. Also, a number of things that we're going to talk about today are matters that are governed by state law. I'm only licensed to practice in California, so that's the window that I'll be providing advice from. If you are in another state, you will always want to consult local counsel because some of these things like contract law can vary quite a bit from state to state. And lastly, just to be clear, the opinions that I'm sharing today are my own. They don't reflect those of my law firm or the other partners at my firm. So I'm going to talk about a few high-level concepts, I think, because I think we'll get more into the nitty-gritty during the panel discussion section. But these are sort of guiding principles that we talk about with creative clients all the time, and that I have learned over years as a designer when I was working as a designer. So just a handful of sort of like core ideas that I hope people can internalize. So to start, this is the first and most important thing that we really try to drill into clients, creative clients, because it underpins a lot of what you're going to do in your business and some of the issues we're going to talk about coming up. And that's the fact that nobody is a better advocate for you than you, right? I think a lot of creative practitioners have a hard time internalizing that both your work product and your experience have value. And I specifically say both of those things because it's not just the work you produce, it's the earned experience that you have that has taught you how to produce that stuff. And I'll talk a little bit in some future points about why that's important. A corollary here, though, is also because of that, because you're your best advocate, you have a responsibility to care about your business and pay attention to what you're working on, because you're the best one that can do that. You can't just expect to hand off projects and things to other people and expect them to care as much as you do. We see so many clients who come to us who will engage us for something, and we'll send them like an intake form to fill out to gather information. And they'll go to the form and they'll just, in one of the boxes, we'll ask for a specific piece of information and they'll just type what I said on the phone. If you can't be bothered to engage yourself with your business and the people you're working with and whatnot, you can't expect them, we care, we work to care, but the most that we can care about your business is still never going to be to the level that you will do that. And you'll see this comes up in some of the additional things I'm going to say next. The other unfortunate truth is, if you are a creative practitioner running a business, you need to learn to love the business part, or at least to tolerate it. Because the reality is that if you're running a creative business, you are as much of a business owner as you are a creative professional. There's just no way around it. So if you can't learn to love it, at least learn to tolerate it, or find someone who you can work with as part of your business to tolerate it. And if you really can't, like if you really 100% just want to get paid to be creative and not do any of the other stuff, consider whether running your own creative practice business is really the best route to that, because maybe you want to get a job somewhere and not have to worry about all the accounting and all that kind of stuff. I can tell you, having run my own practice for 10 years as a designer, you can learn those things. Don't think that it's there's, and we'll talk about this in the next slide. There are a lot of myths around creatives not being able to do certain things, and it's just not true. And unfortunately, like I said, just the reality of running a practice. The next thing, which is hard to convince a lot of creative practitioners, but contracts are not the enemy of your creative process. If anything, in my opinion, one other thing, sorry, just to go back for a minute. The other reason this is important is because if you don't understand the business aspects of what you're doing, it's very easy to be taken advantage of. So for example, we see this a lot in agency relationships, where you've engaged someone to license your work or your talent or something like that. And you don't want to pay attention to it. And so they get really high royalty rates or something. So back to this point, again, contracts aren't the enemy of creativity. Don't buy into the myth that artists can't understand contracts. This is probably one of the hardest things that we have in terms of teaching clients, but it reminds me of back in I think it was the mid 90s, early 90s, excuse me, Mattel produced a Barbie doll that talked, and when you pressed it, it said math is hard, because of this whole concept that girls aren't good at math, right? It's the same kind of myth. Like, you can understand contracts. I 100% guarantee it, because I learned to do it even before I became an attorney. I had my own contracts and whatnot. You don't have to be able to write a contract from scratch, but you can understand the underlying concepts. The other thing is that people are afraid to enter into the contract phase for some reason, right? The reality is contracts preserve relationships. If you have these discussions up front about all the parties' expectations and what are the deliverables and all these material terms, and you lock that down, that frees you up for the rest of the project to focus on the fun part, which is the creativity, right? You don't have to worry there's going to be a dispute about how many rounds of revisions, or what you were delivering, or what happens if they don't pay, or any of that stuff. It's all accounted for. So they're there in part because the process of negotiating the contract builds strong relationships, not because of the end piece of paper, right? The other two big things here, please don't do work without a signed agreement. That's just I know everybody knows this, but they do it anyway. And you just, especially as a services practitioner, You don't have a lot of leverage if you don't sign an agreement. For a lot of what you're doing, if you have a dispute, your damages are going to be, small enough that it's going to be something like small claims court. If you have to go, sue somebody, and if you don't have a signed agreement, you're not going to get a successful claim. The other thing, and this gets back a little bit to what I was saying just before, a lot of people will tend to get engaged by a client and immediately send a contract, right? You don't want to be negotiating through the long form, complicated contract. Have those discussions up front about all these deliverables and whatnot. You shouldn't be sending a written contract. The whole purpose of a written contract is to memorialize the terms that you've already agreed on, not to start negotiations. Excuse me. Get a drink of water. The next big issue is stop giving away your value for nothing. This happens all the time. So to repeat what I was talking about earlier, both your work product and your experience have value. You'll see this a lot with things like, say web design contract. A client comes to somebody and says, I need a website. I don't know how many pages it is or what functionality it needs and all this stuff. And the designer will write up a whole complicated proposal and send it over to the person, the client. And why are you doing that? That's valuable experience and knowledge that you're giving away for free. You just did a consultation. So I know this is a difficult thing for a lot of probably what you guys are doing, but just beware of things like requests for proposals. A lot of them require you to do a lot of heavy lifting up front in terms of providing value and things. There may not be a way around that, but as general business practice overall, just keep that in mind. If you need to, a lot of people will say, well, how do I do that? If you need to, bake in a phase at the beginning of your project where you go through that discovery process or that development process to talk about what you need to do. Again, your experience has value. If they're going to pick your brain about, what to do, they should be paying you for that. This, I think a lot of people conceptually understand, but don't really do it. And it's, as creatives, I think it's vital you understand how to protect your creative work, right? That starts with understanding it. It's shocking how many people don't understand that a trademark or a patent or a copyright are all different things. I've literally had a client email me to ask about something, and they referenced a trademark, a copyright, and a patent all in the same email for the same type of work that we were dealing with. Those are not interchangeable things, and they have different registration processes. They protect different stuff. So understand what intellectual property is, what you are working with. Most of you are going to be primarily focused on copyright for creative expression. Trademark is also important in terms of sort of securing your brand, but understand what those things are. Also, when you're doing contracts, negotiate ownership with clients up front. There are a lot of misunderstandings about who owns what when it comes to intellectual property. A lot of people believe if I paid this person to create something, I own it, which is not the case by default under copyright, at least. And that can often lead to disputes when you get later in the project and you thought you were designing or, creating a video or doing something for one particular use, and then the client wants to use it for 10 other things, and that's not what you thought was happening and didn't price it accordingly. You also want to learn how to register your work because it's very difficult to protect or to enforce your rights if you're not registering, at least in copyright, registering your work. The timing is very important. Depending on when a work was published or whether it was published and when an infringement occurred, you may not be able to do anything about it if you haven't registered your work. So learn those processes and at least identify when you have works that merit that registration. And lastly, learn to understand licenses. By default under copyright, you own all the work you create. You don't have to give that to clients. And a license, that's called an assignment. Instead, you can retain ownership of work and license it to clients to use for specific things. That's very common in the influencer space. That's how we draft creative services contracts by default, is the creator retains ownership and just licenses it to the client for certain uses. It doesn't always work, but be aware that you can do that. And also, if you are working with people like agents who are going to be selling your work, maybe you are a painter and you have an agent who wants to send your work to fabric producers, for example, which is not uncommon. Make sure you understand how those licenses work, so that you can protect your intellectual property. And then lastly, protect yourself from liability. There are a lot of things that you can expose yourself to in the course of practice, particularly under copyright, where you can be on the hook for a lot of money. So in copyright in particular, depending on if you infringe somebody else's copyright, there are damages written into the law that may entitle them to anywhere from $750 to $30,000 per infringement, even as much as $150,000 if it's willful infringement. You want to do everything you can to limit your exposure to those kinds of things. So that will usually mean forming a business entity, like a limited liability company. It's, depending on the state you're in, it can be a little expensive and it seems onerous, but if you form a limited, some kind of business entity like that, or a corporation, in the event something happens, the creditors can only come after the assets of the company. Your personal assets are not at risk. Once you've done that, enter into contracts under your entity's name. Understand how to separate the entity and yourself, and make sure you are doing business and engaging in contracts under the entity's name, how you sign contracts in that way. It can also mean carrying insurance. Ideally, you do both. Insurance covers the business entity and the business entity protects you. But some people will opt only to carry insurance. There are risks with that because, insurers never want to pay out. But lastly, contracts should also address your liability. Meaning, for example, if a client is providing you materials to work with, the contract should say, what happens if they give you material to work with and it turns out it's an infringement and you get sued, right? There should be language in the contract that insurance clients are liable for that. And you also usually want to include language that limits the types of damages that people can get. So somebody can't sue you if you produce something and they say, well, this, I don't know, brochure you designed we thought was going to generate $1 million in sales and it didn't. So that's important. So that kind of wraps up the big picture issues I want to hammer home. I put together a tip sheet here for people to use when reviewing contracts or drafting contracts, with just a few suggestions for for things to look for or keep in mind. So first of all, you always want to clearly define both parties' obligations, right? Generally. So the client should be obligated to a point of contact if it's an organization, and all communications, revisions, etc., come through that point of contract, so that you're not dealing with 50 different people communicating with you. It should also, and I emphasize this because this is one of the places that we see generates disputes a lot, is it should set clear timelines and measurable metrics for whether you've performed. If what we see is a client the contract will say, I will design one, or I will design a logo for the company. The designer thinks that means one initial draft and 2 rounds of revisions, and the client thinks that means 4 initial drafts and 5 rounds of revisions, right? So if you don't have numbered or I should say countable deliverables, you can do other things like set how many hours you will provide. But there should be some measurable metric so that everybody knows, if you've done what you're supposed to do, and and that may involve the clients as well if they're required to provide things on a certain basis or something. Address IP ownership, like I talked about earlier. Specifically, if you're going to be using pre-existing intellectual property, make sure to carve that out so you're not accidentally giving it to the client. Always require some kind of payment up front. It doesn't have to be 100%, but with services, like I said earlier, if you've delivered everything and they don't pay, you don't have much leverage left. So you should at least be collecting enough to cover your initial time and energy for producing the initial set of deliverables. Account for non-payment if they don't. Include late fees and interest, things like that. You're right to collect if you send something to collections they will reimburse you for that. Include terms to address scope creep. This is probably the second place that we see most disputes. Scope creep happens a lot because the contract doesn't address the process for revisions and change orders. So you'll get into endless loops. There's nothing in the contract about revisions, and the client thinks they can just keep asking them forever. So include that, address delivery and acceptance processes, that kind of stuff. You always want to make sure you have a way to terminate, even if it's just for their breach of the contract. A lot of times, if a client breaches, doesn't mean you can terminate the contract. It just means you're entitled to damages for that breach, but you may still need to perform. So you want to make sure you at least have a way out for termination. Usually there'll also be insolvency, things like that. But make sure it includes that. Include limits on liability, like I talked about earlier. Make sure you're entitled to attorney's fees. If you prevail in a dispute, there'll usually be a provision that says the prevailing party in a dispute gets attorney's fees. Without that, it can be very difficult to pursue a claim against the client because you have to pay out of pocket. If they owe you, $3,000, you're not going to spend $25,000 on a lawsuit to collect $3,000. But if they're going to have to pay that $25,000, you might. And if you have a slam dunk claim, then you can get attorneys to take it on contingency because they know the other party will pay it, especially if it's a big party with deep pockets. And then lastly, if it's relevant to your practice, address the use of artificial intelligence. Obviously, this is something relatively new. Both can you use it? Are there limits on what your client can do? That sort of thing. And then lastly, I just have a few resources that I put together that I think are helpful. There's a website called nolo.com that has it's a whole legal encyclopedia, but they have a great section on business contracts. The first of these is a link to the whole list, and then the other three here are just good examples. But it's written in relatively plain English, relatively easy to understand. I refer clients to this all the time when they want to learn about what contract terms mean. So indemnification, for example, if you don't know what that is, it's a great place to go learn. I swear I didn't put this in just for self-promotion, but my firm has something called the Creators Legal Roadmap that I think is very useful in terms of understanding big picture, all the different things you want to be addressing in your creative practice. So here's a link to that. And then lastly, this is a set of free tools that was created by a lettering artist and a graphic designer named Jessica Heish, specifically for the kinds of things we're talking about today. They have tools for doing bookkeeping, hourly rate calculators, email templates for negotiations, and it's all free. And so I think it's a really great resource. Sorry, I just want to figure out how to stop sharing. There you go.
Right. Spencer, thank you so much. And again, everyone, you will receive those tools, that the slide deck and the tools that Spencer's put together will be available after the session. Everyone who registers will receive that. I heard a lot about, artists being able to approach agreements with clarity and confidence, that recognizing unclear language, and asking the right questions can shift contracts from being something that's really intimidating to be a tool that protects you and your work, your livelihood. So I'm going to thanks for those who are answering in the chat. I'm dropping some questions and things so that we can keep the dialogue going. But now I'm going to hand over to Meredith for her portion.
Hi. Thanks, Anika. I love your little pop-up questions in the chat. It reminds me of the VH1 pop-up videos, if that relates to anyone else in a certain age group. Uh, all right. Hi. I'm so glad I'm going after Spencer. That was amazing. I am not formally a graphic designer, so apologies in advance. But I'm thrilled to be here. We're big fans of Creative West and just about everything they do, and it's great to be in community with you all. I'm Meredith Badler. I am the Deputy Director at the Colorado Business Committee for the Arts, the CBCA. Unlike Spencer, I am not a lawyer. I did not go to law school. I do not have a JD. I am not licensed to give legal advice. But like him, I am also not giving you legal advice. So difference in credentials, but same, have to uphold that same standard here. But I am going to talk about some of those, some additional resources. Hopefully, in hearing his amazing presentation, it got you thinking about your own business, your own creative career, your own work. And you may be wondering, what do I do now? Do I have Spencer's phone number? So we're going to talk a little bit about some of those resources, organizations that are here to help, and continuing to gas you up about your self-advocacy as an artist. So a little bit about CBCA. We are pretty unique as an organization. We're a 501c3, so we're not a government agency, we're not a for-profit business, we're not a foundation. We are just a regular old C3 nonprofit. And for about 40 years, we have been connecting arts and business and arts across the great state of Colorado here in the Mountain West. We do that to advance our creative economy through advocacy, through research, leadership training and development, education, volunteerism, and a wide variety of other engagement opportunities. We have a lot of programs at CBCA, and I'm only going to touch on just one of them today, which is our Lawyers for the Arts program. But just to give you a sense of everything else we do at CBCA, and there may be an organization or several organizations that are filling similar gaps in your state. Before I get into that, though, this trophy is for you. Thank you for showing up. As you heard from Spencer and Anika, this is all about agency. Everything we're talking about, no one knows your business better than you. No one is going to stand up for your arts business other than you. There's no copyright police out there. No one else is going to do that for you. This is really about self-protection and self-advocacy and empowerment. So I just want to congratulate you for taking that first step, or maybe this is one of many steps, to get you on that path. However, that doesn't mean getting the help you need is easy, is affordable, is accessible. So that's what I'm here to chat about. So one of our programs at the CBCA is Colorado Attorneys for the Arts, or CAFTA, as we call it. I was lucky enough to help launch our program, CAFTA, about 10 years ago. And so we provide that service for Colorado, which is to connect artists, cultural organizations, and other creative entities with free legal assistance and legal education. And we are in good company. There are close to 24 volunteer Lawyers for the Arts programs or entire organizations across the country. We all talk to each other, we all convene, Actually, the photos here are from when all the NVLA folks were in Colorado this past September. So that's us at Red Rocks Amphitheater. And we are here to help make legal education and legal representation more accessible, more affordable for folks in our area. I know there are some folks on this call who are in states that don't have a VLA, or maybe they don't know they have a VLA. There is a great directory hosted by, there's one with the St. Louis organization and one by the New York organization, so you can find out what you have near you. But we're here really to, all of the VLAs are here to help artists start or grow their creative business, to protect their creative business, and to help sustain it for the future. We do that in a variety of different ways. So we, almost all of us have a referral service, similar to like a matchmaker, where an artist can apply with a specific legal need and then go through some process to get connected or matched to a volunteer attorney to provide that legal assistance, usually pro bono. And there's often a financial eligibility consideration to qualify for pro bono or not. If you can pay Spencer, pay Spencer. But if you can't, call a VLA and see if we can help. Some other things that different VLAs do, and not all of us do all of these, is provide low bono or just regular referrals. So maybe you don't meet that pro bono threshold, but you still like really need to find someone who understands the film industry or the music industry or a public art contract. This can be a way to help you with that search. Some VLAs do have attorneys on staff, so they can take some cases in-house or provide in-house consultations. Some of us do consultations with our volunteer attorneys, so either in-person clinics or virtual clinics where you can sign up for a 30-minute phone call or a 1-hour meeting for just a limited scope conversation or general advice. Many of us do workshops and webinars, so similar to this, on a specific topic. Those can also be in person or recorded or webinars. I know our organization has done many webinars and we've recorded all of them or most of them and put them up on our website. So if you heard Spencer say you should know the difference between a copyright and a trademark, you might be able to go to our website, look on our resource library, and find a webinar about understanding intellectual property and help you get those definitions. Some of us provide online toolkits or workbooks, reference articles, resource libraries. Some of us do advocacy work, which is a natural connection with working in the law or legal fields. And some of us also have additional entrepreneurial fellowships, intensives, or accelerator programs that are legal is maybe one piece of a broader program to help you elevate or advance your creative work. And these are just some of the legal areas that we work in. At CAFTA, we say that must be related to your creative practice in some way, and that can cover a lot of things. So obviously intellectual property fits into that. Some VLAs do patents, others don't. Business entity formation, lots of contracts, employment law. We've had people come to us for leases on studio space, for understanding if they're an independent contractor or an employee, for coming to us for defense. Someone has stolen their work and they need help resolving that dispute or getting damages. Issues with non-payment, issues negotiating contracts, drafting contracts. We've helped artists with estate planning. So really, it can be a very broad spectrum as long as it's tied to your creative practice. And just a couple other tips. I think Spencer did a very beautiful job of summarizing these, but I'll emphasize them as well. That when you're working with an attorney, to respect their time and respect your time, particularly if you got a referral through a VLA program, and your attorney is working pro bono or for free. That is very generous of them. They normally charge hundreds of dollars an hour for that. And they're waiving that rate to help you. So showing up prepared, showing up organized, being clear about what your legal needs are, not necessarily going beyond that scope, that will also help your time. You don't have time to sit around and go back in rounds and rounds and rounds with your lawyer to fix something in the world. So making sure you're really showing up and using that time effectively. And advocating for your needs and being open to possible solutions. We see this a lot, that people come to us, maybe they've been wronged, someone's infringed their work or stolen their work. Maybe they have a vision for their creative business in a certain way, and then when they meet with their attorney, they realize what they thought was possible was not possible, or something like that. I think being open to finding the right solution, and realizing that it's also not a one-size-fits-all situation. Again, no one knows your business better than you. I think there's a lot of information out on the internet. There's a lot of information in AI models. Maybe it's good, maybe it's not. Maybe it fits your situation, maybe it doesn't. Maybe it looks like it does, but there's nuance to your work that it doesn't know about, that you have a certain process or it takes you a certain amount of time. So just, again, standing up, self-advocating for your work. So what can you do if you are in a state or an area that doesn't have a VLA? These are some other places you can look that may have something similar, or get you some additional support. So reach out to your state or regional or city bar association. Every state has a bar association. Every licensed lawyer has to be a member of it. Many of them have directories. Some of them may have an entertainment and sports section or an intellectual property section, or a way that you can search by that. Many bar associations also have pro bono legal referral programs. So that could be a way that you could tap in. Your local arts agency may have similar programs or may have contacts to the local arts or entertainment attorneys in the area. Many states have small business development centers or networks. So even if it doesn't say arts or creative in the title, and it's just entrepreneurial support or small business support, it may still be relevant to you, even if it doesn't have arts in the title. There are also national associations that have great resources, and those can be very industry specific, which can be really helpful, like the Authors Guild, like AIGA. Those are just two of many examples, Folk Alliance, etc. And then one that I forgot to put on this slide is contacting your local law school. Many law schools have what they call clinics, which are essentially student law firms. So students that over the course of a semester, under supervision of a professor, take on clients. And often those can be related to corporate law, community development. So for my nonprofits in the room, you may be able to get free legal help through a student clinic, sometimes an entrepreneurial clinic. I know certain law schools that have a whole music clinic. So that's another area. And then similar to Spencer, these are some of my favorite resources, other books and workbooks. There's some great tools from an initiative called Artists Thrive under the Tremaine Foundation. They have a great sort of survey and assessment tool, as well as a national resource library that I highly recommend. That could actually come to think of it, the U.S. Copyright Office actually has some good registration toolkits and guides. I know that may feel scary, but the Copyright Office does have some helpful guidebooks. Uh, there's some really wonderful estate planning resources for artists. This one in the middle here from the Joan Mitchell Foundation was created by our sister organization in Boston, the Arts and Business Council of Boston. And there's another one that was just published from the Ella Foundation in New Orleans about estate planning for musicians. And then the last two here, the Work of Art workbook from Springboard for the Arts. I believe you can download it for free, or it's a super low cost to get that whole workbook. And then the last two here are some of the resources from Artwork Archive. They have an excellent blog, lots of guidebooks, tools, easy to follow courses to help artists with the business side of their practice. So lastly, again, you're just going to keep us saying it, to speak up. You are now empowered. You've taken this time. Take yourself seriously, take your work seriously, and others will as well. So that's what I've got.
Thanks, Meredith. I am just gonna double down on that. Take yourself seriously, take your work seriously. So many gems that you drop. Thank you, Meredith, and thank you both for those presentations. Now we're going to enter into a bit of a talk show style. We're kind of testing this out and see how it goes, and it's super helpful if you all have questions in the chat. I've seen one, but before we go there, just want to check in with Spencer. Is there anything from Meredith's presentation that you made you think, oh yes, this, or anything like that you want to check in on?
Yeah, actually, I'm glad you asked. So there are a couple things she recommended that I think are really great calls. Organizations like the AIGA are a great example. They have a standard form of contract that you can download for free. So professional organizations like that are a great resource for that kind of stuff. There's another, the Graphic Artists Guild has one as well. It's a book you have to buy, but those organizations are a great resource if you don't have a VLA in your state. The other thing that she mentioned that is a really great resource for artists is legal clinics. When I was in law school, I worked in an intellectual property arts and technology clinic, and we did a ton of work with documentary filmmakers, installation artists, collage artists, all kinds of stuff. So those can be a great resource, and they're looking for people like you because a lot of the people that come to them are people who are looking for pro bono services who don't really need them. And so what they want are real working artists who don't have the funds to do this stuff, especially for things like fair use clearance and stuff, because that can be really expensive. And then the last one is the Copyright Office publications. They have a whole series called circulars that I send to clients all the time. A lot of their stuff is written really plain English. It's not aimed at attorneys, it's aimed at creators. And so a lot of that stuff is great reference, or a great way to start learning about that stuff. Unlike some of the trademark, our USPTO has some publications like that for trademark as well. They're pretty corny, but the Copyright Office stuff is a great resource. So I would emphasize that as well.
Yeah, the Copyright Office actually, I just put in the chat, they have a new sort of registration toolkit. And then just for giggles, they made a workbook called Copyright for Kids, which has mazes and word searches. And I actually think it's amazing. So I encourage people to check out the kids one too.
Nice. Thanks for the wealth of resources that you all have already provided. But now let's just kind of talk a little bit. I was putting some questions in the chat, and one of them was around negotiation. And the fact that negotiating your contract, having that conversation about, the give and take, it can feel intimidating. And someone said that the hardest part for them is clarifying expectations. And then finding that every time they go back and forth in the negotiations, they get more restrictions. And it just keeps on getting like more overwhelming is what I'm gathering from this. And there was another question in the chat about like what it looks like to competitively respond to RFPs while avoiding do a bunch of work up front for free. And I think in our prep conversation, we talked about that labor that is just like there that you're doing. So I'm kind of putting both of those together, like how can we really prepare for that as artists, that negotiation and that preparing for labor that we might not have anticipated? How can we really work on that? Either of you.
Yeah. So I'll take the second one first. I think that, like I said, in the slides, unfortunately, RFPs are a situation where you may not be able to get around having to do some of that just because that's the way they're structured. So I would say to the extent you can, while still complying with the requirements of the RFP, again, bake in development and discovery phases. That's not always going to be possible. If you're bidding on a public art installation for an airport or something, every one of those artists is going to have to do a big, complicated, detailed RFP. So the point is mostly to recognize where you can and can't do those things. If you really want that public art installation, fine, you might have to make a compromise there. You shouldn't be doing it for Disney, right? For like a production con. As far as the first part of it, that's a tough question. I think part of it is a mindset change. Just understanding it's part of the process. You have to learn how to negotiate. But there's some ways you can baby step that. So like one thing that you will see is some people will have a process where their initial contact with a potential client, they have what we call a process memo. That's sort of a canned response that's like, thank you for contacting me about your project. Here's some information about how I work. If this sounds okay to you, just general process wise, right? Here are the phases we go through. These phases typically involve these number of revisions, et cetera. If that works for you, let me know. And I'd love to have a conversation about, moving ahead, right? And so you can kind of cut out some of the people who aren't going to want to like comply with how you work. And so that can be helpful. I think also, like I said, negotiating the material terms up front. So some people will then follow up that with a deal memo or proposal. That's just the material terms, right? Like schedule, fee, that kind of stuff. So you're not negotiating all the complicated contract terms and whatnot. You're just pinning down those material terms up front. That makes things a lot easier. It's more digestible. But also, again, it's like I said, part of it is a mindset change and understanding the value that you're bringing. And so you should feel confident putting like you work the way you work. And if a client doesn't want to work with you because of that, oftentimes the best thing you can do is learn how to say no. If you're trying to negotiate and a client is being crazy, walk away.
Yeah, my answers are somewhat contradictory to each other. So first, I absolutely agree with Spencer of like you can say no. Not every opportunity is the right opportunity. You may see like if this part is so painful now and I'm agreeing to commit to work with someone or produce something for several months afterwards, like what is that going to look like? Like people show their colors pretty early on. On the other hand, I think it's always a cost benefit analysis. And I think this is more related to sort of the RFP question, that sometimes there are moments where the pay is not right, it's too low, or what they're asking for isn't a fit, but like, this is an opportunity that will open doors. I'm not using the word exposure, but like, this is an opportunity that will launch or advance or is like, can get you something else immaterial. It may be worth it. And I think it's just important to know those questions and ask them and then be prepared for those answers and show up for yourself. And so if this is something I'm doing for like half my normal rate, or I'm investing all this time up front because this could be this amazing thing, then that. So then you can go into it with, Now I need to make sure I get that back, that immaterial or that, intangible benefit. Yes.
Yeah, and Meredith, I'm just thinking about the VLAs, right? And I think we've dropped the directories in the chat, and I'm hoping that folks are looking and checking for their states. Um, but like with this scenario, what role, and we want to say, and I think you said it, Meredith, every volunteer lawyers for the arts in each state works differently. So what Meredith does and her, the team of lawyers there do in Colorado might be totally different in Arizona, might be totally different in California. So it's really important that you look at each state, and obviously you have to work with the state that you live in. I think that makes sense because the lawyer is
That's
a
where the
part.
lawyers are licensed. Yeah. There's some
Yes, that's where they're
exceptions to
licensed.
that, but
Okay.
generally, yes. Yeah.
Okay. But like in this scenario, or let's just, in the Colorado case, like if you had a situation like this where either you were feeling overwhelmed, like you're, going through these negotiations, or you have this RFP that you want to thinking about responding to, or, what kind of like walking into a VLA, your VLA, what kind of support might you be able to find to help you with that?
Yeah. I think some VLAs do offer those consultations, though it has to be a legal matter. So, like, should I apply for this RFP? Not necessarily a legal matter. Maybe there's something in that proposal about assigning 100% of your copyright ownership if you get this bid, that you might want to talk to a lawyer about, of like, what does that actually mean? But what we do get a lot of calls for someone saying, I just got my first record deal contract, or I want to hire my first manager, or I just got my first big public art contract. I want a lawyer to help me review that. And so that we see a lot. I think some of our programs, it may take a while to get a referral. So some VLAs are not best for time sensitive matters, but often there's, enough time that you could, um, wait to get a referral and have that meeting. And then you have a lawyer in your court that can, and maybe it's a good deal. And all you're doing is meeting with that lawyer and they're saying, this looks great. Or they could say, you should ask XYZ. Or I'm going to show up to your next meeting and ask those questions for you. Or I'm going to help you rewrite this contract, that's unlikely, but, write your own contract for the next time. So that's how we would interact in that matter.
Thank you. Yeah, Spencer, anything you want to add there? Just wanted to look back before I ask another question.
Well, in terms of, I do think it's important sometimes to understand, like Meredith said, that not all parts of a contract are legal questions. So it might not always be something for an attorney to help with. When you get into statements of work and that kind of stuff, sometimes I'm happy to talk to people about it, but there may be other resources that are better to help, like a mentor or something like that.
Yes. Thank you. That was one of the other things I was going to talk about. Is as a resource is your own community of artists. Maybe someone else has worked with that vendor or that client or that organization before. This comes up a lot when we talk about pricing. Like there's lots of calculators and tools and methodology out there, but one of the best ways to figure out your pricing is doing your market research and looking around, or who do you aspire to be like? So I really can't speak enough about the value of your peers and your creative community on some of those other components.
Thank you. So there was another question in the chat, again about RFP, but I think it's really about knowing your rights and what rights you might have in different scenarios. But this specific question is, if you submitted an RFP and then the client uses your work without you involved, like what rights could you have? Yeah. What do y'all think?
Well, it depends on what part of it they're using, right? By default, under copyright, the author owns the work, right? Unless they sign a written agreement that transfers it. So if you submit an RFP and somebody uses a copyrightable part of that work, then they're committing infringement and you have rights. You may need to deal with copyright registration and the timing of a registration in order to be able to enforce those. Because depending on whether it counts as published or not, there's limits on when you can get damages, like I said earlier. The bigger issue is going to be that sometimes that stuff's not going to be subject to copyright. It's going to be some other, like an idea from your proposal or some like scheduling aspect or something like that, right? Which is why, if possible, in an RFP context, this isn't always possible, but in other contexts, you want to have some kind of non-disclosure or confidentiality aspect to what you submit, where they're agreeing that they won't use anything, whether or not it's subject to copyright, for anything but the purposes herein, right? They won't make use of any of the content of your RFP unless you are selected to produce the work.
Okay, I have to ask, like, how would you do that? How would you include that in in your RFP?
I mean, it's going to depend on the specific RFP. I mean, it's hard to say with specifics because it's always going to be a little bit different. There may be language in the RFP itself that addresses something like that. But ultimately, part of that is also understanding that there may be parts. This is another thing that's important as a creative professional. There may be parts of what you're giving away that aren't protectable. So, this again gets to, like, if it's pretty clear if you submit. So the example I used about the airport public art is actually from an existing project that we've been working on. And those are very detailed, that include renderings and things like that. Those are clearly protectable. But there are other things that aren't, like the idea of what if there's your suggestion is a sculpture of a fish, if they copy that rendering, that's infringement. If they just think, oh, we do want to do a fish, but they hire someone else, that's not copyright infringement. So understand that difference.
Anything, Meredith? Just want to check before I go to a question in the chat.
Oh, I will defer all legal related questions to Spencer. I will just say you'll start getting used to hearing "it depends," which is the nature of the work, but
Yeah.
it's rarely A or B.
Yeah, and I think I started to hear various lawyers I've worked with in various aspects saying it depends. And so we can depend on that. But this is all great food for thought. We have another question in the chat, and before I read that one, I want to invite folks, if you want to ask the question out loud, please feel free to use the raise hand function, and then we'll recognize you. If you want to write in the chat, please feel free to, but I want to make sure that if you're not in the space to write right now and you just want to use the raise hand function, you'll find that behind the three dots on the bottom of the screen, okay? All right, so there's a question that says, what is your opinion on the VARA or VARA clause that clients always want in their contracts to protect their assets? Should this be a non-negotiable to an artist, or is there a middle ground? So I might ask y'all to sort of briefly explain what this clause is, so for the good of the group, and then see how you might answer the question. Spencer, do you want to start?
Yeah, I assume they're referring to a clause requiring an artist to waive their rights under VARA. Meredith, would that be your understanding as well?
Yeah,
Yeah.
that's how I interpreted that as well.
Yeah, so I
To
mean,
waive their VARA rights.
yeah, so to be clear, most of the people attending probably know this, but VARA provides artists certain rights called moral rights in a very limited space, but public art is one of them. We always push back on that stuff. I think there's a reason that legislation exists, and it's to the extent we can, we refuse to waive those kinds of rights because I don't think artists should have to. I guess the other part of that is there a middle ground? I mean, you either waive them or you don't. So there's not a lot of compromise there that I can think of.
Yeah. Visual Arts Rights Act. Thank you for that, Meredith. Another question, what other ways can we invite attorneys to collaborate with artists, i.e., participating in panels like this, conferences, like what? And I'll say that even where the idea for this came up, right? And I'm sure there's people in the chat, in the space, who, just about a year ago started to experience changes. There were a lot of grants and contracts that were lost due to, changes in the environment, and then navigating new contracts, new agreements in this sort of new space and moment that we're in that had a lot of information that was new. And the guidance from various grants officers was get a lawyer. And we can't answer all your questions, get a lawyer. And what we're finding, as a grant maker and those who really care about artists and arts professionals is that we know that folks don't necessarily have the funds for it. So that's where we started to reach out to various VLAs, and also heard from you all that you're feeling a groundswell, lots of artists reaching out more than usual. So I think the question is, kind of tied to that, like what are ways, especially if you're in a state or a part of your state, Meredith, you're based in Denver, right?
Yeah.
But maybe I'm really far from you. Like what are the ways that people can, what are other ways that folks who are more remote, or rural or just, off the beaten path might be able to engage with attorneys to support them?
Yeah, I do think there are a lot of virtual resources. I know that's not the same. But particularly to my friends in rural parts of the state, that may be the best or only way. There are a lot of webinars or things that have been recorded, virtual consultations. We've done consultations with attorneys over Zoom. Or ways that you can access. That's why I wanted to make sure folks had that directory because, there's great resources out of the VLA in St. Louis or Chicago. And unless they're state dependent, which as Spencer referenced, some things are, but things like copyright is federal. So that's not necessarily state dependent. So you can still access those resources. I think there's also, if your state has a state advocacy organization, there's often a lot of intersection between advocacy for the arts and legal representation for the arts, just because they're both dealing with the law. So that might be an entry point. And to your point, Anika, about getting them involved, to me, that's what that means is making sure those who are writing the laws, using the laws, engaging with that on an everyday are hearing from the people that it impacts. And I think there's also an opportunity for just that cross-sector collaboration. So, when was the last time you connected with your Chamber of Commerce or, showed up in their space as well? We see a lot of, as the Business Committee for the Arts, we see a lot of, magic stuff happens when we get all of those folks in the same room.
Yeah, I think Meredith's point about getting involved in advocacy organizations is great. There's a lot of places, not just VLA, but organizations like the Center for Art Law in New York, who's based in Brooklyn. Those volunteer organizations, they want people involved, not just lawyers, but also artists, right? And so that's a great way, like she said, to mix up and meet people from other, to meet, for lawyers to meet artists. I think the the not to sell our services, but I mention this because there are a lot of people like us. We specifically have a subscription program that's a low rate, like $125 a month, that lets you submit documents for review and have calls to talk about just general questions. When we first started, we were one of the only ones, but there's a number of them now in a number of different states. So I know there's one in New York. I should say law firms that focus on representing creatives who also have low cost methods of engagement. So I think part of it is don't just assume that if you hire a lawyer, you're going to have to pay $2,000 against the $500 an hour retainer, right? There are a lot of them have easier ways to get engaged. And then just as far as like collaboration generally, I think the point about clinics earlier is like a lot of clinics would be very open, even if you didn't have a specific issue. If you contacted them and were like, I'm a working artist, I'd love to like be engaged somehow with what you're doing, and come up with a project. Because they do all kinds of stuff. It's not just representing you on a specific issue or something, right? They write amicus briefs for like the Supreme Court. So for example, the clinic I was in, I wasn't involved in this, but they wrote an amicus brief for God, what was the issue? Well, I know I can tell you one more recently for the Warhol fair use case that came through the Supreme Court a couple of years ago, which was a big deal. And they need somebody to be the like client on that. So especially if you're an organization, like they wrote an amicus brief about the DMCA, which is an online copyright issue, a few years ago, and I think it was the Authors Guild was the client on that. So if you have an organization, that's another thing you can do, just to get involved and be in touch with them.
Yeah. Okay, thanks for that. Oh, there's two things that I thought of, and I didn't get to touch in with you all, especially about the one, because it's something I learned about recently. When we talk about different legal designations, I've been hearing recently about these ACOR, artist corporations.
Oh.
I can talk about that
Okay.
because they don't
So
exist yet, but they might in Colorado.
right.
Oh.
Yeah, buckle up, Spencer, because it might be coming to California too. If it
Yeah, I'd love to
passes.
hear about that. And
Yeah.
then I'll just, so that you're thinking about this too, just rights when it's in, this is another evolving thing. AI and like protection of your work, protection of songs, protection of visual art, like all these different dynamics that are coming in terms of AI. Just kind of speaking to it, obviously both of these things may not be definitive. But over to you, Meredith.
Oh my gosh, we've been on for an hour and that's like the first we've talked about AI. Yeah, artist corporations, they don't exist yet. It was an idea brought forward by a gentleman, Yancey Strickler, who is one of the co-founders of Kickstarter, but also has a background in the music industry and other creative endeavors, with the idea of our current sort of business structures and capitalistic structures don't accommodate for some of what makes creative enterprises unique, and have somewhat actually blocked us out of some of those opportunities to access capital, to access benefits, to protect and divide up intellectual property in different ways. So it's a concept. There's actually a bill that got introduced in the Colorado legislature just last week, which would be the first step in creating this new business entity, which is a sort of a modified LLC. The idea is to make forming A corps very simple, a lot simpler than forming an LLC, with some sort of some upfront sort of forms to create them. There'd be opportunity for some equity sharing and different access to capital and funding. So it's really, it's a business entity specific to our creative field. So we will see. We're excited about it. We're helping on the advocacy effort for that. Uh, so that's all I can really share at this time, but I encourage folks to read about it, to learn, to follow along. Colorado may be, I hope, the first to be able to register A Corps.
Yeah, that's fascinating. I actually hadn't heard about it before, so I'm very interested to look at this.
Yeah. Spencer, do
Thank
you want
you.
to take the AI question?
It's actually simpler, at least at the moment, than a lot of people realize. So the big issue in AI, particularly with regard to creatives, is copyright. Our work at the moment, work produced by work produced by artificial intelligence with very, very limited exceptions that are almost impossible to meet, is not subject to copyright. And I think that's super important for people to understand, for a couple different reasons. One of the big ones being that if you're engaged by somebody to produce creative work, your contract will usually say, uh, there'll be language in it where you represent and warrant, which is a contractual way of saying promise, that all your work is original and you have the right to grant them the client ownership in that work, and the client will be able to exploit it and stop others. If you produce that work in any part with AI, that's not true. It's not subject to copyright. If somebody infringes your client's work and it turns out they can't enforce it, you've breached that part of your contract. So it's super important to understand that, particularly if you're in an area like film and television or music, where chain of title is an important issue, which is proving ownership from creation all the way up through the distribution of like the film. But yeah, I think there are a lot of misunderstandings. I have seen in our creative community, because there are works that have been granted copyright. Most recently, there was one called a slice of American cheese or something like that. That's like this well-known one. But it involved this long, complicated process where the person who was producing the work was very specifically trying to produce a process that would create copyrightable work. And in the end, it only covers certain contributions of the artist, not the whole thing. So it's not going to, it's not, for what most people are doing, it's not going to be subject to copyright.
Yeah, I think there are some other concerns about just the future of creative jobs in the field of copyright. That's not necessarily a legal issue, but one that I know is top of mind for folks, and a lot of juicy philosophical debates about the role of creative expression through human history and what it means for us to have, original works. And I think yeah, we're gonna see how that plays out.
The one other thing I would add is, which I already addressed a little bit in my slides, but is also ensuring, what is done with your work in relation to artificial intelligence, and that people aren't allowed to use it to train LLMs to, one of the big ones that we add to services contracts is a language that says the client's not permitted to upload the work to any AI or machine learning platform. Because a lot of clients will do that to get feedback on stuff. And so we'll include language that says you can't do that. If you do that, it's a breach. You have to pay us everything you own, and all rights revert back to us. Because training is a big issue. Because part of one of the current suits that's going through right now, I think it's the Anthropic suit, actually established that the training part is not necessarily infringement, it's fair use. But it's how people how Anthropic, for example, got access to the literary works in this case that they train, which was piracy. And so what they did was wrong, technically not because of the training, but because they acquired those works, inappropriately, which is what you would address in your contract. You're not allowed to use this work for that stuff.
Yeah, that's really interesting. I have seen things saying, this is a public document for, this is something that we're giving to people to use, but in order to use it, you must agree not to put it into
Yeah.
an AI model. Yeah, pretty
Fascinating.
cool.
Yeah, thanks for that. We're going to start to wind down and make sure that we have time for closing and for the session feedback form to get lifted up and things like that. But I would ask you all if you have just one thing that you would love folks to know, like if nothing else, and it can be something that you've already said that you want to double down on or triple down on, but that one thing that you need them to know above all in this moment. I will start with Spencer.
Yeah, that's a tough one. Can I do two? I'll give you two that I've already said. But I think for one, both Meredith and I both said it. Learn to show up for yourself and advocate for yourself. And that's really, like I have said a couple times, can be about a mindset change, but it really is a fundamental part of successfully running a creative practice. The other one is don't do work without a signed contract. Please stop doing work without a signed contract.
You took mine. Mine was going to be get it in writing. That is the number.
Yeah.
If you apply for a referral through us, that is the number one thing I'm going to ask is, do you have a contract? Do you have something written down? Yeah, that's and you know, there are people out there that want to help you. I was so honored to be asked because most people live in a state with a VLA and they don't know it, or if they don't realize that there are law school clinics, bar associations, local arts agencies, other programs, trainings, fellowships. Like there are free consulting. There are so many people who want to help you. Um, and it just takes asking, booking, again, showing up for yourself. So know that those people are ready and waiting. They're waiting to hear from you.
Absolutely. Well, I want to thank you both for your time and just the wealth of resources that is in your slide deck, in the chat that you added along the way. I know just from being an artist and knowing this community, like all of this can feel overwhelming. But I want to encourage you, like when we send out this deck and this presentation and the chat so that you can get all the links if you didn't get them all. Maybe it's forming a group with your artist friends and your, hey, let's split this up, right? And then let's have coffee and then we'll talk about what you learned when you went to this site and what I learned when I went to this site. You know, it is doable if we kind of show up together and support one another, as we often do. But this is now yet another way that we can support one another, right? Come together with artist friends, creative friends, and kind of, you know, we say eat an elephant one bite at a time. Still an elephant, but only do it one bite at a time. But let's also do that together. So again, Spencer and Meredith, thank you so much. I think you have given us years of information. And just a reminder for those who may have come late, you registered for this session, so that means within the next 48 hours, probably less, you'll receive a link to the session, to the slide decks. It'll be up on our website as well. So all of that information is going to be coming to you. So now I'm going to hand back over to Ashanti and Marcelina to close us out. Thank you so much.
Thank you so much, Anika, and thank you, Meredith and Spencer, for all of this incredible information that you've shared today. As mentioned, we'll share the slides with all of you along with the recording. And just a reminder, please make sure to send in that feedback survey. It's already in the chat. This helps us learn how we can enhance these webinars. Also, please make sure to join our current newsletter. This information shares opportunities from our grants, awards, and programs team. You can find information about grant opportunities and other organizations in our Creative West network and access to resources, additional resources like these to strengthen your work. So we also have that information. Okay. And then what's next for the capacity building webinar? For organizations, April 14th, this will focus on succession planning and knowledge, ways to explore how to plan leadership transitions with care. And for artists, May 12th, is building your own artist residency. So you'll learn about designing an artist residency rooted in values, community, and place. Okay. I want to thank you all again for joining us, and please make sure to come by next month. And we look forward to seeing you again. Thank you.
Thank you.